Hi guys, this is Mike Edwards, and the subject of this video is trial preparation in child custody court. Very important video, and I'm going to have April, my office manager, try to encourage people who have a child custody case to log on to the website and check out this video, because it tells you some stuff that you need to know, particular to child custody cases. And in the hubbub of busyness, sometimes I don't get all this out to you. I usually do, but maybe it's better for you to see it right before the trial. Sometimes I'll tell you some of these tips maybe the day of trial, and things that you need to know right before you get on the stand, things like that. Other things I'll tell you up front, but the points that I may make in this video kind of cover areas that maybe it's best to get this now before we get to trial, as opposed to right before we get on the stand if you got a situation where we have to go to court for trial. And that's kind of the focus of this video, what to do in court for trial preparation. Been trying cases for 35 years, and you can't help but observe some stuff that is crucially important in a child custody case in front of a judge. And I'm going to point some of those things out to you here. Let me first start out by saying that in child custody, it's so emotional, and it's involving your whole life, your child or your children. And I understand that, and I want you to know that there's a big delay a lot of times between the time we file a case in custody court and the time we get to court. It can be 6 months, it can be 2 years. I mean, it can be a long time just because of delays and things that happen. It's usually not that long, usually 3 to 6 months we're in court on the trial part. But there's a lot of lag time, and I know there's times when you think, well, gosh, Mike, I paid him money to represent me and hadn't heard from him in a month, and what is he doing? well, I'm probably doing somebody else's custody case during that time. But just know that during the time that there may be dead time, and this is probably the biggest complaint I have amongst clients in custody court, they think that I'm not paying attention to their case. And I want you to know from my heart that when you hire me for a case involving your kids, I do a case plan, and we follow that case plan. And if you don't hear from me, that means that nothing's going on in your case. If I hear something about your case, if the other attorney contacts me, if there's a court change, if whatever, then we're going to be in touch with you. If you have something vital in your case that has come up, you contact April. April's going to handle it most of the time, but she's going to be talking to me too. In other words, I might not pick up the phone myself and call you about an issue unless it's a major issue that we need to talk about, and if that is the case, I will call you. But April and I are in discussion all the time. If you call April, it gets to me within hours, and we'll discuss it. She is my right arm, and we get an answer back to you. And also, even though nothing's happening in your case, that doesn't mean I'm not thinking about your case. I'm aware of your case. In my drawer, I know all my cases, and we update them. I review them periodically if the court's coming up, just to keep abreast of what's going on. If you've brought something in, I review it. So I'm up to date daily on your case, so I know what's going on and know what's happening. So I may be thinking about your case in the shower. I don't know why that happens, but I may be taking a shower, and all of a sudden I'll think about something in your case, and then I'll get on the phone in the car, and I'll say, hey, make this notation in Jane Doe's case. It just occurred to me something we need to think about. or put that in there on my case plan. April's constantly updating your case plan in my file. If I think of something in the middle of the night, and I'll get up and next morning I'll remember it and I'll put it in your file. So just know that your case is just as important to me as it is to you. If you pay me money to go to court and fight for you, I respect that, and I'm going to earn that money that you paid me, because I know it's hard-earned money. You worked hard for it. You work hard for your money. You pay me. I work hard for my money. If you hire me, it's as simple as that. And I grew up in a middle-class home where my parents worked very hard. They put me through school. I didn't have to pay a dime. I love my mom and dad. They're both gone, but I love them, and they taught me that. They taught me that, you know, their deal was they're going to pay for my education, and what I had to do is study as hard as I could do, and I did that, and make them proud. That was the deal, and we didn't sign a contract. But I knew that was the deal, and that's the deal I have with you as my custody client. You hire me and pay the money you worked hard to get, and sometimes you have to take it out of your retirement. I know all that, and sometimes you have to borrow it, and I know that. Well, I'm gonna work as hard for you as I can to earn that money that you paid me, just like my parents did, to be able to earn the money to pay me or pay my college and law school. That being said, let me talk to you about a couple of trial tips. When we're in child custody court, we'll be sitting there, and sometimes I'm looking up at in fact, most of the times I'm looking at the judge. When somebody's testifying, I'm looking at the judge. And some of my clients, it's kind of funny, some of my clients will be talking to me, and I'm trying to listen to them, but I'm mainly watching the judge. And I know what you're saying is important, and I hear it. And I'm trying to filter that. And I've always been able to do 4 or 5 things at one time, so it's no big deal. It doesn't bother me. But the reason I'm looking at the judge is because the judge is the one that makes the decision. And over the years, I can tell from studying judges like I do. I've got OCD, so I notice stuff. I can notice from their expressions kind of how the case is going. If some witness says something, if they make a facial expression, and they do, judges do that. Or if they're making notes, if they're sitting there writing down notes, that means maybe they thought that was important. If they're not writing notes, it's not important. So that gives me an idea as the case goes on. So I watch the judge like a hawk, just like I did as a DA. I used to watch the jury's faces all the time, because it tells you a whole lot. And sometimes it causes me to change my strategy in a case. So just know that happens. And I also say this, judges also look at you guys. You know, somebody's on the stand, your husband's on the stand, and he's talking about you, and he's saying all this stuff that's totally bogus, totally a bunch of junk. It's not true, and you know it's not true. Well, the judge is going to be noticing you and your expressions to that. And you may not think that, but the judges do, and I talk to them all the time, and they'll say, well, your client really upset about such as. You got to be Mona Lisa. Do not have any reaction. If somebody calls you a four-eyed, purple-headed, whatever, do not show expression. Don't get upset. Why? Because in custody court, your expressions, even if you're not like that, your expressions in court say something to the judge about your stability and your ability to handle stuff. And in custody court, a judge is looking for the most stable person to take care of these kids. And if you can handle somebody calling you a four-eyed, purple-headed whatever without getting all bent out of shape like a pretzel, that tells the judge something. That tells the judge something about you as a person. and about your ability to be the stable parent that can handle anything. Anything the kids get into or anything that the kids need, it tells the judge something about you. Don't forget that. So you got to keep your emotions under control. I'll tell you that before we go to trial, but I'm telling you that now, so hopefully you've seen this video before we go to trial. But the judge is watching you. They get bored up there, and they look around and they notice that. Also, your witnesses need to keep under control. If we got witnesses in court, they need to keep under control too, and I'll tell you that. We need to be Mona Lisa in court. Just let it roll right off your back. Okay, another thing you need to think about too is when you're on the stand testifying, don't ever say my child. That's a big pet peeve with judges because it's not really your child. Now, we're hoping it's going to be your child as far as the result in terms of you get primary custody, but it's our child. It's a small one, but it's a big one. So try to remember that. Another tip, don't ever let the other attorney get you mad on the stand. That is a killer. Goes back to what I said a minute ago, stability. There's a couple of attorneys that I've dealt with. One of them's in McDowell County that tries to make every custody trial of the Jerry Springer show. And the judges know he does that. It's ridiculous. Absolutely ridiculous. Now, I'm going to be the first one to argue and raise my voice if it's necessary, but only if it's necessary to make a point. And there's a way to do it. I don't go in there and start throwing my arms up in the air and shouting and badgering people and stuff like that because it scores 0 points with the judge. Judges are smarter than that. They are smarter than that. And so it plays well to the crowd, maybe, the amen crowd out there in the audience, but it doesn't play with the judge. Judge is one making the decision. So when you're on the stand and you have an attorney that is screaming at you or calling you a whatever, you need to stay calm and answer the question. Now, I can protect you there. If the attorney's cutting you off when you're trying to give an answer and is not letting you finish, I'll be the first one to object and say, Judge, let the witness answer the question. I mean, that's what I do. So I'll protect you back there, no problem. But you got to not get upset. If you get upset, get mad. If you start arguing back with the attorney, then you get in the same low road boat that he does or he's in, and it brings you down as far as your stability for the judge. Judge wants somebody stable that can handle anything, including a knucklehead attorney that is stupid. And that's what it is. So remember that. I'll tell you about this for the trial, but I just want you to be thinking about this ahead of time. Another thing, let's see. Oh, don't let an attorney cut you off. If somebody asks you a question, you can theoretically you can answer that till the end of time. You can take till God terminates life on earth. You can keep talking. There's no time clock in custody court. So in order for you to answer a question, see, if you start talking and answering a question and the attorney cuts you off, that means you're hurting him or her. If the attorney cuts you off right in the middle of your sentence, that means what you're saying is hurting his side or her side. And that's a good thing for us. So you need to keep talking. Don't stop. Because if you stop, then you can't complete your answer. And a lot of times, isn't it true that such and such happened? And you start explaining, it may take about, 3 paragraphs to explain it. And you get about 2 sentences in, and he cuts you off and asks another question because he didn't like your answer. Because your answer is giving the truth. Keep talking. Talk right over him. I'll help you there too, because once he starts cutting you off, I'll say, objection, she's not, or he is, whoever, he or she is my client. Let the witness answer the question. But sometimes if you just stop, the judge will look at you and you just freeze up. So just keep talking. Just keep talking till the judge will say either sustained or overruled on an objection. So just keep talking until the judge stops you. That's another important tip. A couple other trial tips I'm trying to think of here. Yeah, make sure before you come to court, make sure if you have any notes, and I tell my clients a lot of times to keep a record of what's going on in your custody trial. If you have notes, bring those with you. You can take them to court with you. I tell my clients to keep a calendar to mark important things like missed visitations or cancel visits or things like that, or if you have video, or not video, but text messages that are nasty, you need to go to CVS Pharmacy and get those printed out. We don't want to put your phone in evidence, but if your other side is sending you bad messages or things like that, you go print those out and you hold on to those. That's evidence, so I can't take it, but you let me be aware of it or make me a copy, and you keep the original you got it from CVS, and we'll introduce that. But you can take all that stuff with you to court on the stand and testify from it. You can testify from notes on the stand. You can take a notebook if you want to of what's going on and have dates, make sure it's dated. It's impressive to a judge if you get up there and instead of just saying, well, here's what happened, you can say on March 16th, this happened, and you pull your notes out, and you've got the notes to show you recorded it. Those are the things that I would ask you to do in trial prep for custody. Just know that I'll be as prepared as I can be, which is totally prepared for your case when it's ready for trial. Don't worry about me. I'm ready. I know what I need. If I need something from you, I'm going to be letting you know that. If I don't have all I need, I'm going to be calling you, or April's going to call and say, we need such and such. So if I don't call you and say I need something, that means I've got everything I need. You keep me aware of what you're doing as far as documentation. And then before the trial, you'll let me know what's going on. We'll know that all the way through the procedure. We'll be in it for a while. So communication is the key, back and forth, and April and you will do most of that. Then she'll get it to me, and I'll put it in the file, and we'll add it to the case plan. So those are some things that I want you to think about. I've gone on too long on this segment, but I think it's important. Child custody, I know, is crucially important to you and your life and your kids and your family, and we'll get there. It's a tough process. It's draining for you and for me, but that's what I get paid to do, so it's no big deal. But just know that I'm with you 100% in what we do. I'm behind you 100%. I'm going to give you advice that I think is correct advice. I'm going to tell you what I think you should do. You make the decision. You know, if we're talking about settlement and I say I think we need to do this and here's why, it's based upon my experience, primarily with the judge we're dealing with or the facts of your case. It's not because I just want to get it over with. If I tell you we need to keep going to trial, that means we need to keep, what I'm trying to tell you is I hope you'll trust me because I've got your best interest at heart. I promise you that. I appreciate all my custody clients. You guys, I don't know. I remember almost every custody case I've ever been involved in, especially the ones I went to trial on. And we've had some good success, and it's because you have listened to me and you have followed your case plan that we come up with for you, and I think we've been very successful. And I appreciate you trusting me, A. Michael Edwards, to do your case. And I know sometimes it's from referrals from other people, but those folks, I appreciate them too. And it's A. Michael Edwards, attorney at law. I'm Mike Edwards. It's the same person. And we're here for you at any time. Give us a call if we can help you. If you're a current client, then you know that April's right there, and she'll get the word to me, and we'll help you out too. Thank you for listening to this segment, and I hope you'll think about these things before our case and trial prep for child custody. Thank you.